Hey, everybody, it's Eddie, and we have some really interesting information for you. I have been so lucky to get the thumbs up for John Deaton and Jeremy Hogan to join me. Both are practicing attorneys / YouTube sensations. No, maybe not, but I think both of you have missed your calling. However, on a serious note, the XRP holders I know are very, very, very grateful for your time to help us better understand all the documents that have been released, and in particular, getting our heads around the SEC versus Ripple complaint. And I know that sometimes the communication coming from both sides has been really hard for us to keep up with. I mean, I imagine if I'm feeling that way, I think a lot of other people are feeling that way. So thank you very much for taking your time to come and answer some of the questions that have come out on Twitter. I really, really appreciate it. And the communication in the last few days has just been more than I expected, with the answers on the amendment coming from Ripple that was filed, and then we had the denying of the Tetragon request that was coupled with the Ripple official statement. And then John, you received a reply in your work with what you are doing to prepare for a class action suit. I guess the SEC has given this motion to dismiss, and I think you're going to be able to explain that to us a little bit in more detail. And then the SEC now has put the blame on the exchanges, which is just crazy. And then we have some good updates and tweets that have come from both Brad Garlinghouse and Stuart Alderati, who I really am also very thankful that they're keeping us in the loop as to what's going on, because it's a really confusing time for everyone. So John and Jeremy, thank you so much for coming. And John, if you want to do some quick introductions, both of you, that would be just great. So go ahead, John, you go ahead and start.
Well, thank you, Eddie, and thank you for having us. And it's finally nice to meet Jeremy as well, sort of in person. Yeah. And by this time, everybody knows, the funny thing about me is January 1st, when I filed the writ of mandamus against the SEC, about 12 days later, someone said, John, how long have you been a securities lawyer? And I said, oh, about 2 weeks now. So it's not necessarily my forte. I'm represent people who died from mesothelioma or are dying from mesothelioma, but it doesn't take a securities lawyer to figure out what the SEC is trying to do here, and it doesn't take a experienced securities lawyer to read the Howey test and see that that it's just not gonna fly what the SEC is trying to do, at least as far as today's XRP, versus maybe 2013 to 17 XRP. But everybody should know me by now.
Yeah, I think you've done a really fabulous job in getting yourself out there in the crypto Twitter for sure, and it's been, I think, I am positive people really appreciate the work that you've put in so far, and I continue, I'm sure, to put in after this. Jeremy, you too, you have really been an overnight, sensation is not really the word I wanted, but that's the word that's coming to my brain. The reason why is because you have this really superb way of taking something that's very serious, because I mean, we're talking about people's money here, but you've been able to give us a tiny bit of humor along with it, and a lot of insight and knowledge and perspective that for most of us, the world of legalese is very foreign. So you have really, really helped me. So I'm positive you've helped a lot of others too. Yeah, well, tell us a little bit about what you're up to.
Sure. So, I don't know if it comes from this, but I was a teacher for a couple of years before law school. So I taught in Japan for a couple of years down in Kyushu. And then I taught high school for 2 or 3 years. So I don't know if it's because I was a teacher. I just enjoy trying to explain things to people who aren't in the legal field is just something I always had fun time doing. And about 2 years ago, me and my wife, we just, you know what, let's do a YouTube channel. And we started doing some videos. It was just for fun. It still is for fun, to be honest. And you know, our YouTube channel was kind of just going along, you know, it was nothing great. And then I saw this, well, and then just to back up, about 2019, I got very interested in Ethereum and blockchain and crypto technology. And I really hadn't thought much about it, you know, before that, except my friends who were mining it. And I thought they're kind of weird, you know, with all their computers in their attic or whatever. So that was all I knew about blockchain and cryptocurrency. About 2 years ago, I started getting into it, mostly about, I was interested in contracts, really. And the idea of a smart contract just blew my mind. And I was like, wow, this is amazing. So I was just kind of doing the videos and interested in kind of a lay people kind of way about blockchain. And then I saw the SEC lawsuit come out and I go, wow, this is really interesting. And literally it was right after Christmas that I first even really heard the word XRP in any serious kind of way. And I looked at the lawsuit and I was kind of going online and seeing what people were saying about it. I was like, I just quickly realized that people really didn't understand what was going on. So I did the first video and, you know, we just do the YouTube channel for fun. I think YouTube pays us about the equivalent of $1 per hour. So it's really not for the money, but
Yeah,
we do the YouTube channel for fun. And what keeps me going is the XRP community is so supportive. Like, you know, John knows if you go on the internet, you're going to get all sorts of crazy people that just say all kinds of crazy stuff. But for the most part, the XRP community is the most supportive, nice, like it's amazing the comments you get in the comment section and even on Twitter, they're just so thankful. And so sometimes you're tired and you don't want to do it and you're just like, oh, I just want to go to sleep. But then you look on your YouTube or you look on Twitter and they're like, come on, Jeremy, do a video. What's going on? And it kind of gets you going. So that's what I'm doing. We're just doing it for fun, but I kind of keep coming back because of the community.
yeah, this particular community is unique, and I know everybody wants to think that they are part of a unique situation, but the community is really hungry for knowledge, and they're open, and they are probably one of the widest, in my opinion, not geographically speaking, but in terms of the representation of humanity. You know, it's just amazing. You know, it really is amazing. It's quite special.
People all over the world, Malaysia, UK, you name it, they're paying attention to what's going on here.
Yeah.
Because it is very important to them and to their investments. So, and I understand that.
Yeah.
Eddie, I'd be remiss if I didn't also just make sure that people know how appreciative I am. They have been overwhelmingly supportive. And I won't take a lot of time, but there was a project I did in the past where I was trying to get Claire's to get their asbestos contaminated makeup out of the children's store. And I spent a considerable amount of my own money. I was just trying to get it out. And I got lambasted by the public, like that I was like, you know, trying to bring down the store and, you know, just crazy comments and negatives. So when I filed this case, I was expecting, okay, you know, half the people are going to support me and half the people are going to say I'm like some money hungry attorney who's just trying to get attention or something. And 99.9% of the XRP community has just been amazing. And what that does is it makes you work harder, and it makes you, it's what Jeremy said, if he's tired and he really doesn't want to do a video because he's tired, he sees everybody wants it, and so it gives him that kind of pep. And this whole experience has kind of rejuvenated my enthusiasm for the law, to be honest with you.
Ah, it's really nice to hear. Yeah, really nice. Well, let's dive into some of these questions, and then I will just be a good listener. I'm going to let the two of you really just get through the ones that I think represent what a lot of people are thinking. And the first one is, it's really about this kind of interwovenness between the case that, let me just find it here. Okay, so what is the interplay between the Ripple lawsuit and John's lawsuit? Because there is some dynamics that are playing off each other.
Sure, I'll take that. The what people need to know, technically what I filed is not a lawsuit. It's called a petition for writ of mandamus. I started drafting the lawsuit, but then I realized that you have to give the SEC 6 months before you can sue them. You have to give them proper notice, and then after the expiration of 6 months, then you can file what's technically a lawsuit. Obviously, with the exchanges delisting XRP or suspending it and halting it, I didn't want to wait that long. And I also, when I saw the complaint from the very first line said from 2013 to the present, that they were alleging that today's XRP in 2020 and 2021 is a security, I just still to this day have a hard time imagining an SEC attorney standing up in court and saying that the XRP and my Coinbase and Uphold exchanges are illegal securities and everyone else's XRP. So a writ of mandamus is when you're asking the judge to direct an officer of the United States to do his job. And so I technically filed the case when Elad Roisman was the acting chairman after Jay Clayton stepped down. And so I served him with the complaint, and it's asking the judge to order him to amend the complaint so that it only alleges securities in the earlier time frames where there were distributions, say between 2013 and 2017, because that's where I believe is the only chance the SEC has of being able to prove it's a security. And so I'm saying, because there is no good faith basis to claim that all of our XRP holders, all of our XRP are illegal unregistered securities, do your job and amend the complaint. And Jeremy, actually, if you go back one of his earlier videos, he was very generous to me and in his comments about the work I did, but he was like, you know, Deaton's probably going to lose this. And that's accurate, probably, because in order to be successful for a writ of mandamus, I have to prove that I have no other legal remedy at law. And when it's usually a discretionary function, the separation of powers, the judge isn't going to tell an executive that you have to do something if they have the discretion to do it. But there is some case law where it's such a gross abuse of discretion that a judge can step in. And of course, I'm claiming that the SEC, by filing it the way they did, with the circumstances that they did it, that it was a gross abuse of discretion. And so the judge in Rhode Island could very well say to me that I have another remedy, that a lawsuit, and it's all about money, calculating the damages. You just have to wait. And he could say that that's an adequate remedy. Ironically, and it's a good thing, but ironically, when Uphold and I think GateHub and is maybe BitTrue, there's a couple that did not suspend. So technically, he may find that because not every exchange suspended or delisted or halted, that I have to wait, that I'm not damaged, or the XRP community is not damaged, that we can transfer it, you know, to another exchange and then begin trading. And then as far as the damages, as far as the value of the asset and how it was depreciated by the SEC's action, that's just money damages, and you can wait the 6 months, you know, and then file your case. And so, but, you know, I filed it intentionally because I think the SEC, and I don't want to be too mean, but I think it's just in complete disarray. I think that Gensler is walking into, you know, they can't even agree. They're writing public letters against each other and how to approach it. And quite frankly, you know, I spent 7.5 years in the Marine Corps. So, you know, sometimes I look at strategy as in like the military sense, whereas that the SEC and Ripple are engaged in a frontal assault. So I'm going to come and I'm going to flank the SEC on their flank and make them divert, you know, maybe distract them. The left hand doesn't know what the right hand's doing. And also, the SEC actually in their language did exactly what I wanted, which is I had hoped to have a hearing by now and then actually get language from the judge that would help me make the next move I'm going to make. But the SEC pretty much did it in their motions. And so there will be a next move that is very an interplay, if you will, with what's going on. But as you can see, what the SEC wrote and this inconsistency, I mean, if you read, I sent a tweet out about Brad Garlinghouse and them should read this thing, because what they're saying to me is that all I'm showing is that it's possible that it's something has been committed, a grievance has been committed, right? It's the same thing that they're alleging about Brad, right? Where they're saying that, well, it's possible that he knew it was a security, but that's not the standard. And so that's about as much as I can say now. I will tell you that this time next week, I think everything's going to come into focus about what we're doing here as the XRP community and how it's really going to come into play, in my opinion, with the SEC and the Ripple case. I know it's a little vague, but stand by. I promise it'll be worth it.
Big news coming. If I could, Eri, if you don't mind, if I could just piggyback off of that. I think it's really important for people in the community to understand how important what John is doing is, and they really need to get involved. And I'm going to tell you why, because John's a litigator like I am. And so he's playing 4D chess here, and he's got a strategy, which I'm guessing I kind of know what it is, but I'm gonna wait till the big announcement next week. So, but here's the other thing that's super important is this judge in the Ripple case. So John's got his case. We got the judge in the Ripple case, Judge Torres. She needs to understand the effect that all this stuff is having on individual holders of XRP, right? Because right now you have SEC versus Ripple, which is a relatively big company. You got Brad and you got Chris, who are, let's just say they're not poor, right? So you don't have much sympathy going on there. And when I look at a case as a litigator, I'm always wanting the judge to feel bad or feel sympathy for my client, think that my client is the good guy. So what John is doing is he's getting all the individuals together into his lawsuit. Now, in federal court, you have to always file what's called a notice of related cases, right? So the judge needs to know what cases are there out there that are kind of related to the case that I'm sitting on. So the judge is going to know that John's lawsuit is out there. And the judge is going to see all of the effects that this SEC versus Ripple lawsuit is having on individual holders of XRP. And that is super important because she needs to know all of the things that are going on with John on the street holding XRP. You know, he's been putting $500 from a paycheck in for the last 5 years or whatever the case may be. She needs to understand that. And so John's case is getting that information in front of this judge. If she's a good judge, which I think she is, she will know one way or another that his case is out there, and she'll have someone review it and tell her what it's all about. So it's not just about a writ of mandamus, and it's not just about damages. It's also going to be affecting this SEC versus Ripple case. I was almost thinking, John, that someone would want to file a amicus brief or something for the individual holders, but what you've done is almost file an amicus brief in the case through your writ that you filed. So I think what he's doing is super important. I don't want to underplay that. So really everyone needs to get involved if they can.
So is that a good time then? We should mention, John, you have a website that everybody can use as a resource for a link to a Google's doc that people can fill out. Is that right? Yes,
that's right. Thank you, Eddie. It's and thank you for Jeremy for those words. Crypto.law.us, crypto-law.us.
Right.
And they can access the forms. Once they fill out those forms, they'll get a notification that they're sort of in the system, if you will, that they're part of it. Those that did not go straight to the form and emailed my firm has already been emailing folks to fill that form out. And what that form does is just allows us to keep track of it in a database very efficiently.
Good.
So,
All right. Can we move on?
sure.
Okay. The next one was, what if the court finds Ripple XRP sales to be a security, but they don't find any others a security?
Let me jump in on that one real fast. So I'm not sure what they mean by others. I assume they mean other.
Maybe other assets, maybe.
Yeah. Well, I think we need to step back and first off look at what's going to happen at the end of this lawsuit, because I think people are a little bit. I hear the word a lot, used a lot. What's the word? We want some kind of designation that it is or isn't a security, or we want some kind of certainty. And really, what the SEC does is they regulate by enforcement. So they regulate by filing lawsuits. They can decide not to file lawsuits, so they have some kind of leeway there, but they regulate through enforcement. And that generally doesn't give you the kind of, I think, the certainty or the designation that people think it does. So when people ask me, what happens if the SEC finds that XRP is a security? Well, what I do is I look back at the case where that just happened. I think it was last year or late 2019. That's the Kick Interactive case, right? Mm-hmm. So the Kick Interactive case was sued for basically the same thing by the SEC. It went through discovery. It went to summary judgment. And the court found that they had sold a security, Kick Interactive Company. It was I think the KinCoin, K-I-N. Mm-hmm. Anyway, so the outcome of that litigation was essentially three things. One, the Kick Interactive Company was enjoined from further violations, which is kind of meaningless because of basically saying, don't break the law again. Well, it's kind of a given, right? The second thing was there was a fine. In the SEC, what is called disgorgement. So you're supposed to kind of give the money back that you made from the sale, but really it's a fine. And then the third thing, which is the most interesting thing, is that the Kick Interactive Company was not allowed to make further sales. This was in the order, in the judge's order, unless they registered it as a Register D sale, and they only sell to, which means they could only sell to accredited investors. So this is the big thing. When I look at the worst case scenario, I look at the Kick Interactive case and I say, what happened there? Well, really, Ripple could probably pay the fine. They, of course, would agree not to violate the law again. Now, what happens to the XRP that Ripple holds in escrow? That's what this is all about. Because if Ripple has to only sell that XRP that's in the escrow, I guess they're not really technically selling it, but whatever's happening with it, if it can only go to accredited investors, what does that do to Ripple's business? What does that do to the price of XRP? Is that, and I don't know the answer because I don't understand Ripple's business like that. But that's what you have to think of when people ask, well, what's going to happen if it's found to be a security? Well, it's not really designated as a security. What the court's going to say is that the sale of XRP by Ripple at that time frame, was a sale or wasn't a sale of a security. So it's not really designated a security. It's the sale that the SEC is looking at, not what XRP is. XRP can change. XRP, it was a security then when it was sold, and now it's not. These things change. So you're not going to say, the court can't say XRP is a security, right? Because they're only regulating and enforcing the sale. So for example, Ripple sold XRP to, let's just say you, Eri, let's say you had a contract with them. I know you didn't, but let's just say. So you bought one XRP from them for like half a penny back in 2015. Now that sale to you could have been a sale of a security. You've held it in your wallet since then. And now you say, John, I'm going to sell this to you for 50 cents. Now, John is buying it from you. You're the seller. John's not looking for you, obviously, to increase the value of that. You're Eri, his friend. So obviously, when you sell to John, that's not a security. You're not selling a security. So you kind of can't look at it like it is or it isn't a security. It's that point in time when the sale is made. And that's what John's lawsuit is kind of trying to find, is kind of telling the court there is, look, this might have been, I'm not even saying it is, but if it was from this point to this point, it could have been a sale of a security. But from 2015 to 2020, it obviously wasn't a sale of a security. So it's not kind of an all or nothing. You got to look at the point of the time of the sale.
Sounds like
Yeah,
it's going to be difficult for the judge. Go ahead.
well, I was just going to say that, you know, every token starts off arguably as a security, and that includes Bitcoin. You know, Joseph Grunfest, who was a chief at the SEC, believed, he had made statements that Bitcoin was a security when it was the Bitcoin Foundation was, and they only had a couple few miners or a couple mining pools. You know, it acted like a security. Ethereum absolutely was a security. I believe even more than XRP in the early days. And Bill Hinman, who came out in 2018, said, well, today's Ethereum in 2018 is not a security, even though it started off as a security. And that's the real distinction. What's different about this case is the SEC with that language that says to present. And because I think the question there was trying to distinguish other XRP holders, whether or not if the court says that when Ripple sells it, it's a security, but when John buys it from Coinbase or Uphold, it's not. And the bottom line is, I don't think that it's functional where they're going to be able to devise that, okay, when only Ripple sells it, it's a security in present, I'm talking present day, but then by the time, you know, they sell it to MoneyGram, it's a security. MoneyGram sells it to Coinbase, you know, it's a quasi security. And then when Coinbase sells it to John Deaton, it's not, it's a commodity. It's too complicated and convoluted. And so the whole issue is what the SEC, the only viable claim that they have, in my opinion, is that in 2013 to 2017, when there weren't as many use cases, when there were less development of XRP, that arguably back then it was a security. So.
That's absolutely right. And, you know, I talked about this, I think a couple of videos ago, but we really got lucky with the draw of our judge, because for a judge, she's relatively young. She seems very intelligent to figure out what John just said, starting from zero knowledge of cryptocurrency, blockchain, to what John just said. It takes someone, you can imagine, it's going to take someone of very good intelligence that's willing to dig in and learn this stuff in order to figure that out. And so, you know, this case is probably, in my opinion, going to come down to summary judgment, which is the judge making the decision. And that's what happened in the Kick Interactive case. So I don't know the individual defendants, if it makes it there, which I don't think it's going to, I think they're going to get dismissed, but that's just my opinion. They might go to trial because there's issues there to try. I don't think that the security status of XRP is going to make it to trial. I think it's summary judgment. The judge is going to make the decision. And I think we have a judge that's going to be able to make that distinction that John just brought up.
And finally, back to Jeremy's point of what people want. What people want in the XRP community, they're not going to get from the court. It's only Congress. What they want is what the UK did with the Financial Conduct Authority, where they said, hey, we've got three types of tokens: a security token, a utility token, and an exchange token. And we find XRP to be a hybrid between utility and exchange token. You know, that kind of clarity is what, you know, is needed in this country, but it's not going to come from the case. And when people talk about, well, Ripple test is going to replace the Howey test, okay, that's 5 years with the United States Supreme Court coming down with some kind of test. And so that's to get the clarity in the court system, the way the XRP community wants it, would take years. And so, go ahead.
I just think, with that being said, a successful outcome or a settlement doesn't give you the clarity that you want, but it does effectively give you a designation that it's a non-security. Because if you have a settlement, or if you have a judgment in your favor, the case is over. I mean, the SEC can't sue you, lose, and then try again. It doesn't work that way. That wouldn't be fair. So you're going to get effectively, you're going to get some kind of clarity, or at least as far as Ripple is concerned, as far as XRP is concerned, even though you're not going to get a piece of paper from a judge saying XRP is not a security from now until the end of time. You're going to effectively have that.
Good. All right. Here's a question. Can you sue exchanges that halted trading? Jeremy or John, what is your thinking about this?
Well, the answer is you can sue them. The question is, are you going to find an attorney that will sue them? And here's the thing, Kraken CEO, co-founder Jesse Powell, what's his name? Right. Powell.
Mm-hmm.
Yeah, he responded to a tweet that I did today, where I retweeted his and made comments, and he responded. The exchanges, when the securities, what he tweeted was basically they have to believe that the SEC acted in good faith by bringing the case. And so if the U.S. Securities Agency says XRP or alleges XRP is a security, they have to mitigate. They can't say, they're now on notice, right? That if it's deemed a security and we keep trading it, then they can come after us at a minimum from the point that they filed the case against Ripple, and then seek fines and penalties from us. So what I said when this went down, 95% of general counsels for a Coinbase, especially with an IPO, or a Kraken, a lawyer is going to say the safest thing to do is to halt or suspend. That way you can say that you were on notice when the SEC claimed this about XRP, and you didn't just ignore them. Yeah. Now it takes someone, and I know that JP at Uphold, he's got securities lawyers. That's the best of them, and they've looked at it, were confident that it's not going to be deemed a security, and made that decision, and I applaud that. But the exchange could turn around. If we sued the exchange, they're going to turn around and say that they were under almost a quasi-legal obligation, where you have to like mitigate your damages, sort of kind of theory. It's not a perfect analogy, but I'd like to see it. Jeremy probably can explain it. He's better at explaining these complex things better than I am in a succinct way.
I think you're doing great. Well, I'd like to just step back for a second. So what I see online when you're talking about the Ripple situation is you have two different kinds of lawyers out there talking about it. And when I get the question, can you sue the exchange? Well, there's really not a good cause of action for that right now, okay? But you have two kinds of lawyers out there in the world. There's more than two, but you have two general kinds of, you have the regulatory lawyers and you have litigators, okay? So I see a lot of the regulatory guys, and there's nothing wrong with them. I'm not talking down to them, but their job is to look at the law as is and tell a company, don't do that, or do that, or don't do that, or do this, because this is what the law is. And when you see all the lawyers online that are saying, Ripple's gonna lose, they're in trouble, they're mostly regulatory lawyers, because they're looking at the law as is, and they're looking at the Kick Interactive case, and they're saying, how are they gonna distinguish this? And I mean, it's true, and Ripple's got a job to do there. Then you have the litigating lawyers like John and myself. We look at the possibilities, because it's in the courtroom in front of the judge that law is made. Okay, that's stare decisis. That's the system that we're in. So when John files a writ of mandamus, when John files a lawsuit against the SEC, the regulatory lawyer or the guy who's looking at the case law is going to say, oh man, that's not a good lawsuit, you're going to lose that. And he might be true. But John and myself and other litigators sometimes are not thinking about what the law is now. We're thinking about what the law can become. And so you have a different mindset when you're in court, because, and the other thing about being in court is you never know what the judge is going to do. If you have a case that is going in front of the judge, the law might say XYZ, but if you can get the judge to believe ABC, you can get that judge to rule your way. So always keep that in mind, that you have two kind of different mindsets, and neither of them are wrong or right. But John is thinking, what can I make the law become? Not what is the law now? And that's, I think, when you see the Ripple test, that's a litigator talking. That's a litigator talking. It's like, oh, we don't need the Howey test. It's going to be the Ripple test. So you know where that guy's coming from.
And by the way, there are only two types of lawyers: trial lawyers and then everybody else.
Little closer.
That's what trial lawyers say.
Sometimes when you get too far back, your sound gets a little muffled. So just, yeah,
Okay.
but yeah.
Sorry.
Yeah, it's helpful. Very helpful. How about going to, if XRP is deemed a security, we might have covered this one. Do retail investors have to be, oh no, this is new. So if XRP is deemed a security, do retail investors have to be accredited to hold or to sell it? But you said it's probably, yeah, go ahead.
I was just going to say that normally what would happen is that if theoretically, if it was deemed a security inherently, Ripple would be ordered to buy it back from our retail investors. It's called rescission. I believe it's the legal term. Jeremy, correct me if I'm wrong.
I think you're right. I don't know how, in my thinking, there's the problem is, so it's not so much if Ripple loses this case. My instinct, and I don't know Ripple's business, and I don't know the effect it would have on XRP if Ripple's business takes hit. My instinct is that Ripple continues on even in the worst case scenario here. My instinct is that, I mean, there's more to the world than the US, right? So we're not, I think that Ripple continues on, XRP continues on. The Kin token is still out there. It's not doing very well, but it's still out there and it's still being sold. And the problem becomes in everything that happens around it. So if you get a stigma around XRP because there's an adverse, judgment or whatever might happen, you have banks that maybe don't want to be involved with it. You have exchanges that don't want to be selling it. So it's everything in the universe that circles around XRP, I think, where the problem comes in for the holders of XRP. Not so much the core of the business, but everything that kind of goes with the business. And I don't know that business. That's not what I do. So I don't know that business extremely well. But that's where XRP is going to take a hit, I think, if there's an adverse ruling. It's not so much that XRP is going to be a security, so we can't hold it and you can't sell it to us and this and that. I think it's going to be all the other things that go with XRP are going to take a hit, and that's going to cause that.
It should be noted too that the last statistic I saw was that 80% of XRP is traded outside the United States. In fact, I think the SEC, they may have some difficulty proving that Brad sold his XRP in the United States. It's something that, as you know, there's a jurisdictional issue there. But if 80% is traded outside the United States, how's that affect the 20% in the United States? It's an interesting question, but I really don't believe we're going to get to the point where there is that kind of decision where it's deemed a security. Personally, I think that's a good hypothetical question, but I don't think it's going to play out in reality.
When I first looked into it, and I ended up buying XRP a couple weeks ago, my analysis was to look at it and say, okay, what's the worst case scenario here? Okay, I just see something that was trading at 70 cents and now it's trading at 20 cents. Why did that happen? And is this lawsuit a good reason for that to happen? And what I came to the conclusion was, you know what, even in the worst case scenario, this continues on. And if the use case is there, it's still going to blow up and be a big thing in the world. And that was where I came from. And I still think that's true. Partly for what John just said is because, Americans think of themselves as the center of the world, but we're not really, we're here and we're important, but there's more to the world than us. And XRP will continue on in those places where it is. Ripple, if they have to, they could set up shop in Tokyo or wherever they want to. So it's going to continue on, I think, no matter what happens with the lawsuit. But I really don't think that there's going to be an adverse judgment in the lawsuit. I agree with John on that.
Good. All right. Will a case dismissal for XRP as a non-security, will case dismissal determine XRP as I get it. So if they dismiss this case, if the judge Annalisa Torres decides to dismiss the case, does that put XRP as a non-security? That's the question.
So
Go ahead, Jeremy.
So, well, she might dismiss. So Ripple hasn't moved to have the lawsuit dismissed. So right now she could only dismiss the case as to Brad and Chris. And there's two ways a case can be dismissed. You can dismiss a case with prejudice, without prejudice. If you dismiss it with prejudice, that means that the other side is lost and they can never refile. That would act as a non-designation, as close as you're going to get from a court. If she dismissed, sometimes a judge though will look at a lawsuit and say, you know what, I need to dismiss your lawsuit because you didn't plead it correctly, but I'm allowing you a chance to fix it. That would be kind of a dismissal with prejudice, or I'm sorry, without prejudice, or without prejudice and ability to amend. Yeah. Now, as to Ripple, the only thing the judge is going to be able to do is grant summary judgment. And I think if that comes down, I think it's going to be a judgment either that it is a security in a sense, or it is not. Or what I'm hoping for is the judge gets a little more detailed and does what John is talking about and says, look, maybe this was, maybe this wasn't, and parses it up. Because what the SEC is trying to argue is that there was one big coin offering from 2013 to 2018, which just lasted for an eternity. And it's just not the way, it was, and it's not correct. And the Kick Interactive judge, unfortunately, ruled that way, but he only had about 2 years of coin offering to lump into one big coin offering. Plus, he was about 83 years old at the time of the judgment. So I'm not sure how much he was getting his mind around of what was going on. So
yeah, good.
Yeah, I'm very confident that the only judgment that is going to be entered ultimately against Ripple is a finding that specific distributions from 2013 to 2017, that those specific distributions constituted securities, but it has transformed from that period of time to now. And so it's almost like a split victory. You know, the SEC might get a victory that, okay, you know, when you sold, you know, 500 million to this person or this entity in 2015, that was a security offering and transaction. But sort of like what Bill Hinman did for 2018's Ethereum. But today, it just can't be considered a security. And so I see that as the only way the SEC gets a victory in this case.
I think the SEC has a big problem, and this is something that's been coming up a lot more and more in the recent pleadings with the fair notice and the due process arguments. Now, the way I think Ripple wins this case is to give the judge a framework on the Howey test, right? The problem that Ripple has right now is you got that Kick Interactive case that's sitting out there with somewhat similar facts, at least at the first glance, similar facts. And you have a judge from the same court that ruled against Kick Interactive. That's a big problem for Ripple because Judge Torres probably, you know, these judges know each other. So they probably, you know, she went to lunch with the judge and Kick Interactive. They'd attend meetings together. And they tend to want to kind of have the same thought process on similar cases. So Ripple's really going to have to distinguish that Kick Interactive case from what was happening with Ripple between 2013 and 18. Yeah, say this is completely separate situations, Judge. And they got to hit that hard. But I think the way they really win it is, first off, they give the judge the framework, they give the judge the argument in the Howey test and say, look, you could rule our way and here's why, under all the prongs of the Howey test. But then they've got to go in hard, and I think they're realizing this. They've got to go in hard on the fair notice and the due process. The fact that FinCEN said that it was a currency back in 2015-18, because, and John knows this, when you're in court, you got to give your trier of fact a legal basis for finding your way. But then you've got to also make them want to find in your favor. It's two parts to it. So you give them the legal basis, but then you also have to give them the moral impetus that they want to do it for you. So I think that the fair notice and the due process parts of this case are so important because the judge has to say, you know what, SEC, you really messed this up. It's a mess. How could you have waited this long? How could you have done this and this and that? And then she's going to be, you know what? You're kind of right. Why do I want to rule for SEC on this? I want to rule for Ripple because the SEC just didn't do this the right way. So that's how I kind of look at it. And I think that's how Ripple can win the whole kit and caboodle.
Good. Okay. One more. The SEC just stated that they cannot be blamed for the delisting of XRP at the exchanges because there is no determination as to what XRP is. How can they sue Mr. Garlinghouse and Mr. Larson for selling unregistered securities? In their own words, there has been no determination.
That's a great, right?
Uh-oh. You got stopped again. Yeah, there.
How about now?
Good.
That's a fantastic question, and it goes to, from what I see, the strongest argument the SEC has is some 2012, even though Brad wasn't there, opinion from a law firm that says that, hey, it could look like a security. Some people, the Securities Exchange, might consider the security. Now, Brad and them say in their answer that ultimately that letter concluded that it wasn't a security, only that they were warned that it could be. And what I tweeted out was this argument where the SEC says to me that, and it's quote, the plausibility standard requires that the person bringing the case, that's the SEC, show more than a sheer possibility that a defendant has acted unlawfully. So they're saying that to me, that I'm trying to bring a case against the SEC, and I'm only saying that it's possible that they violated the law, if you will. Then it says where a complaint pleads facts that are merely consistent with a defendant's liability, it stops short of the line between possibility and plausibility. Well, that's the same thing for Brad, right? In other words, yeah, it might be a security, but it might not be a security. Under the law, they have to prove more likely than not that he believed it was a security. They have, that scienter and that specific knowledge that he had to have. And if they don't have anything more than what they've pled, I agree. I believe Jeremy's already intimated he believes Brad gets dismissed, and Chris Larson as well. And if they don't have anything more than what's shown here, I think they're getting out. I think they're going to be dismissed, and they should be dismissed. And this all wraps into what Jeremy was saying about this fair notice due process argument. Just think about this, not just the 7.5 years, all right, but you have them allowing a 9% purchase of MoneyGram, where they know that XRP is being, what they call in the complaint, subsidized, right? MoneyGram calls it market development fees from Ripple. They then sell it to Coinbase or whoever on the exchanges. The SEC is allowing that to happen, and then they even get into the minutia of their reporting. In the fourth quarter, in February of 2020, the MGI changed the way they reported it and called it a contra. But the SEC didn't say to them, hey, these are securities, right? And so if all of that's happening, how does a person of reasonable intelligence know that they're violating the law? And so it's the SEC is what I said before, they're all over the place. They're inconsistent in everything they're doing. And, it's going to be really up to Gary Gensler to walk in there and really straighten things out and dictate policy. Do I think he's going to come in there and say, okay, dismiss the case? No. But I think that he's going to need to find a way to save face for the SEC and get this behind him. I'm not quite sure if I didn't answer the question, Jeremy. Go ahead.
No, you're right. You're spot on. I would just say we get a lot of is the judge going to dismiss the case against Ripple? And where I stand as to the individual defendants, but with Ripple, cases don't get dismissed like that. Or no, I'm sorry. The question is the SEC going to dismiss the case? That never happens. Litigators have too much pride. So if I sue John's client and I know that my case is not going well, I don't just dismiss it. I call John and I say, you know, John's got the phone call before. Hey, John, what's going on? Hey, hey, you know what? Maybe we just get this case wrapped up here. Let's just get this done. So that's what'll happen if SEC, if Gensler comes in and says, look, we need to get rid of this and we're going to backtrack and start something else. You'll see a settlement is how it will be. There won't be a difference.
Eddie, if I could say too, this is such an important point because the SEC is really engaging, in my opinion, in jurisdictional expansion. You know, the CFTC just went after McAfee because of Dogecoin, and that's a commodity, apparently. But I guess Ripple and XRP is a security according to the SEC. And so they keep it vague, right, for a reason. Look how many times Jay Clayton and the others would not comment on XRP or anything else. They just gave the pass to Bitcoin and Ethereum and some public statements, and they never commented either. And then in the answers, the motion dismissed to me, they then say, we didn't tell the exchanges to suspend it or delist it. That's on them. And that's because they want to be able to come back if they are successful and go after other crypto. There's no doubt in my mind. There's absolutely none. Look at the last risk alert. I know Jeremy did a video on the risk alert. It basically says, you know, we're putting everybody on notice that you need to be compliant, and anything we say in this can't be used against us, but we're putting you on notice for the future. This is without question what Jeremy said earlier of regulation is going to be established through the enforcement. They're not sure what to call XRP, so we're going to sue Ripple. We're going to declare it, but if we lose, okay, we lost. But if we win, now we can go after everyone else. That's personally what I believe is happening.
Absolutely, absolutely. And you know, I used to work for a big insurance company, which will remain unnamed since they are evil. But I was part of an insurance company, and they would literally have roundtable sessions where we would talk about 5-year litigation strategy, because the way you change the law is you do it in steps, right? You get a judge to give you this, then you get a judge to give you that, then you get it, and then now all of a sudden you've got what you want, but it takes time. So I saw the same thing happening with what the SEC was doing. You can almost see how they started off with some of these really small little companies that really couldn't defend themselves. And they would kind of get a little case here, they get a case there. They went up to the Kick Interactive case, and now they've got that case, which is going to cause a problem for Ripple. So they were working their way up the food chain, so to speak. And I think Ripple was their first big bite that they've tried to take. But it really is kind of scary when you see what they're doing, because I've been involved with that before, and I see how it plays out. And they just want to devour everything. Everything is a security in the crypto world, according to the SEC.
And why, the last thing I'd say about it is, why did they use the language they did? You know, for example, Brad Garlinghouse saying, I'm very long XRP. And then in the complaint saying, but he sold some. Well, you know, if you have 1 billion XRP and you sell a couple 100 million, you still are very long, right? Jeff Bezos sells $1 billion of Amazon stock every year. He still's got millions and millions of Amazon stock. But why do they plead that? Because that's not goes to any element. There's no fraud claim. They did it strategically to make the other crypto projects, the maximalists out there, you know, get mad, get angry, say, oh, they just try to enrich themselves. It's a classic divide and conquer strategy.
Mm.
Yeah, that's a good point.
Yeah, it's I'm sure that's what it was. And I also agree with you that they're trying to get that door open wide enough with a judgment on their side so that they can go after all the other coins. And that's where it kind of seems surprising to me that there isn't more unity among the entire ecosystem to rally behind XRP, because it's in their own best interest as well. And it kind of confuses me why we don't see that.
I've started to see some blockchain lobbying groups or groups, and I think one has, I saw something about one having a meeting with some of the higher ups in the Biden administration. That's the type of thing that really needs to happen. But, you know, the amount of money.
Blockchain Association, right?
Yes, that's the.
Yeah. And there's there's 2 former Ripple employees that are in that association now. And so, yeah, they're I'm sure going to be a good voice. And also that whole association is full of some really great people who represent the space. Yeah, so it's good too. I was happy to see that.
Well, you're not the only one that's like surprised and confused by it, because the last time I checked, markets are supposed to decide who wins and who loses, right?
Right.
Not the government, not certain regulators, because the regulators change every 4 years. Right. It depends on who the president is. So it depends on which way, you know, but last time I checked, a real system is, okay, if XRP ends up being, you know, S coin, well, let it be an S coin on its own merits, right? Let it fail. Don't suppress it and play favorites, because you have a regulator who might be connected to other projects. Stay tuned for that.
You know, the problem with the system is, and you know, the SEC is no different than the insurance regulatory body in Florida here. You know, I don't think of them as bad people. They're in a system where the whole kind of project is moving towards greater and greater regulation. It's just the nature of a regulatory body like the SEC. And so I don't think, you know, I see a lot of bad names online, and I don't think of these people like that. I just think they're part of a system where that is just the DNA of what they're doing. And so really the reason why the lobbying and they got to spend some money on the politicians is so important is because that's just going to happen unless unless Congress gets involved. So really the fix here is a legislative fix. It's not a court fix. And I think that's why I think the Blockchain Association, all those different groups, they've got to be funded, and they've got to be out there, and they've got to be pushing the narrative that the blockchain groups need to be pushed, because otherwise the SEC monster is just going to gobble up everything. So,
yeah, the pains of going through a very nascent ecosystem. It's still maturing, it's still changing, it's still being understood, and that's a huge educational process still needs to be done. We're so new in this space.
We have politicians who are talking about how cryptocurrency is used for nefarious purposes, and I believe last year it was 0.03%.
Yeah, I just can't understand that. When I still hear that, I just can't understand that.
I don't see my local drug dealer paying in Bitcoin yet, on the corner. Yeah, I'm transferring a Satoshi to you for my bag. I think we should look at cash first.
Yeah.
Yeah.
I heard there is a really good member of the Senate from the state of Wyoming. She's really sharp. She's really been behind Bitcoin for a long time. She was introduced to it many years ago. I think she's going to be very instrumental, along with Caitlin Long, in moving a lot of that education along. So, yeah.
I think we just got to get Brian Brooks back in somewhere, the government.
He hasn't appeared back into his new role yet, has he?
No, do you know where he's going?
No, I don't know yet. I'm sure, though, it'll be probably something impactful, because he's a kind of impactful kind of guy.
Yeah, he is. He single-handedly helped this industry remarkably.
Yeah.
You know what I mean? Remarkably.
Everybody will always, those people, at least in this space now, will always look up to him, I'm sure.
Yeah.
Well, gosh, guys, we have gone over an hour. I think we hit a lot. And I really think that the XRP community and the holders of XRP and the people who are not even holding XRP, but those that really now I do believe are aware that this case is going to have some effect on the whole system, the whole ecosystem. I appreciate the time that you've taken out. I know it's getting late on the East Coast, and so we'll, I think, wrap it up. I'll just let you have any last minute words, and then we'll say goodbye to you. So go ahead. Maybe Jeremy, you go ahead.
Sure. I just like to thank everyone for the support for our YouTube channel. It's really been a very nice thing to have. And you know, I was doing all my videos, and you know, you get a comment here and there, but the outpouring of support for my time that I put into explaining these things has really it kind of touches your heart. So I like to say, everyone, thank you very much.
They're really, really fun. John?
Yeah, I have to second it and tell everybody. I've been, you know, I'm 53 years old, and I was really burnt out in my legal career, and sort of disheartened, to be candid. And as appreciative as everyone is of my efforts, they have no idea how appreciative I am of them, because they sort of rejuvenated me. They've even, you know, when you there's a comment here or there, but when 99% of the people are that supportive and show you, it lifts your spirits. It actually made me a little bit more positive towards humanity again, because I think I was in a negative phase, you know what I mean, personally. And so I'm internally grateful. And all I can tell you is when you get that kind of reception, you work harder and harder, and you fight harder. And we're going to continue to fight. Trust me.
Yeah, I'm happy for that. And I totally agree with you, just because I have the same kind of motivation that brings me to do more research and, you know, get to the truth on a lot of issues because of everybody's support as well. So I really am in total agreement. I feel the same way. All right, everybody. Okay. Yeah, do take care. And we're going to say goodbye. And I just want to say again, thank you. And we look forward to following you both on Twitter and also with both your channels. I'll be sure to put them in the description below on this video so that everybody can access them easily. All right.
Thank you.
Take John, care. Keep it, man. Good luck.
All right. You too, brother. Talk to you later.
And take care. Thanks, Eri.
Good night. Bye-bye.